good afternoon, everybody. Welcome to this latest in our series of Waitman's webinars. Today's topic is COVID-19 post-lockdown, considering and safeguarding against future risks for directors. Today, we're going to be providing essential guidance for directors and their advisors on how best to manage their fiduciary duties through these turbulent times, how to mitigate risk in light of the new normal, and how to deal with the fallout from that. Before we start today's webinar, if I can remind you that for the best possible audio experience, use headphones. If at any time during the webinar you've got an issue, please use the hand button on your screen and organiser will contact you. For the Q&A section at the end, please use the questions box throughout. The organisers will be picking up questions, which we'll deal with at the end of the webinar. And finally, we're all presenting from home, so please bear with us if there are any technical difficulties, if you hear doorbells ringing, dogs barking, or if small children make an unexpected cameo appearance. So without further ado, I'm going to introduce you to myself and my fellow speakers who will be presenting to you today. My name is Kieran Donovan. I'll be kicking things off in a moment. I'm a partner in the corporate team at Waitman's, and one of my specialist areas is advising directors on their legal duties under the Companies Act and related legislation. I also lead the firm's owner-managed business group in Liverpool, and I work closely with business owners and their advisors, helping clients grow their business. My colleague Charles Boyne. Charles is a partner in our restructuring and insolvency team. Charles is going to be speaking to you about the practical steps directors can take to avoid falling foul of the law when a company is in financial difficulty. Charles has a wealth of experience in disputes relating to finance and insolvency. He acts for financial institutions, business owners, and insolvency practitioners. And historically, Charles has also acted for the Insolvency Service disqualification proceedings, and has also acted on the first compensation order case as well. Our third speaker, delighted to be joined by Marcus Haywood. Marcus is a barrister practicing at South Square Chambers, who are the leading insolvency law chambers. Marcus has appeared in many cases involving directors' duties, particularly in an insolvency context. Marcus is also a contributor to one of the leading textbooks on directors' duties produced by Oxford University Press. And Marcus is going to be discussing the potential exposures directors have when a company goes into liquidation or administration, with a particular focus on the government's proposed suspension of wrongful trading and what impact this may have on claims against directors. And finally, last but not least in the shadows, is James Moore. James is also a partner in our restructuring and insolvency team. James deals with all forms of corporate and personal insolvency. And James is going to be speaking to you today about the difficult decisions directors have to make in the current climate, how to walk a fine line between acting reasonably and responsibly, as opposed to taking a reckless approach to taking out government support. And he'll also touch on some of the new measures due to come into force as a result of the Corporate Insolvency and Governance Bill, which may become essential tools for directors to use to get through these financially difficult times. Now, in a few seconds during the presentations, we'll disappear from your screens, and then we'll return at the end for a Q&A session, which I'll be hosting. So please do post your questions throughout, and we'll pick those up at the end. Okay, so with the introduction over, I'll start things off with an overview of the current law on directors' duties. But before I do, just perhaps helpful to frame this presentation in the context of where directors find themselves today. So between the disruption caused by the pandemic and constraints imposed by government to contain its spread, businesses are faced with unprecedented levels of uncertainty, and reliance is therefore being placed on directors like never before to take action in response to an ever-evolving situation that demands new measures which impact their business. And as the situation evolves, so too must the focus of directors. But their actions always must be informed by their duties and their other legal and regulatory obligations. So in particular, company directors, well, they must act in the best interest of stakeholders, especially so if a company is struggling financially. Directors can still be personally liable. They won't be able to hide behind the temporary business support measures we've seen. Now, we recognise the company directors are working really hard to get their businesses back up and running. And in fact, with the focus now turning to the recovery phase, directors are going to be working harder than ever before to ensure that not only are their businesses ready to reopen at the relevant time, but that they've got the working capital and the liquidity to do so. So, What are directors' core duties and liabilities? Well, it's worth remembering that although every company operates through its board, its individual directors are bound by the Companies Act 2006 and by the Companies Article of Association in terms of how directors conduct themselves. Now, subject to any such rules and to the need for directors to be able to demonstrate that they discharge their duties properly, directors are pretty much free to arrange their affairs as they see fit. Now, before the Companies Act 2006 was implemented, directors' duties were actually based on the common law fiduciary duties of good faith, loyalty to their company, and the duties of skill and care. However, those duties are now set out in sections 171 to 177 of the Companies Act 2006, but whether directors have complied with such duties will still be determined largely by historic case law. Now, it should also be noted that general duties are owed by all directors of a company, not just a select few, and there's no distinction between the duties owed by executive and non-execs. They're identical. So on the next slide, we're going to look at what the overarching duty is. And that's set out in section 172 of the Act. And I don't propose going through each of the directors' duties in turn because we simply don't have the time. But I'm going to focus instead on this overarching duty. So what is it? Well, it's set out on the slide there, and it states that director must act in a way which he or she considers in good faith would be most likely to promote the success of the company for the benefit of its members as a whole. And this overarching duty requires directors to have regard to those key factors which are set out on the slide. Now, in considering the overarching duty, it's important to note that the duty applies to decisions made by director, not necessarily by the board as a whole. Success isn't defined, but it is intended to mean long-term increase in value, and that will be a good faith judgment by the director. Those factors listed on the slide, well, they're subordinate to the overarching duty to promote the success of the company for the benefit of its members as a whole. It's a non-exhaustive list of factors. There's an obligation on directors to exercise reasonable skill, care, and diligence when having regard to those factors. And a court's more likely to be persuaded that a decision was not taken in good faith where no reasonable and intelligent director could have concluded that it would promote the success of the company. It's also extremely important to note that if a company threatens to become insolvent, the duty imposed by this section actually shifts to creditors over and above those factors listed on that slide. And I'll talk about that in detail in a few more moments. And finally, in addition to directors' core duties, there are various other statutory duties and rules which directors are obliged to adhere to, including those covering loans to directors, health and safety, and so on, all of which are going to become increasingly relevant as businesses reopen from lockdown. So on the next slide, we're going to look at to whom the directors' duties are owed. And they're owed to the company only, and so only the company will be able to enforce them, and a company will generally take enforcement action by its board of directors. Now, in certain circumstances, however, the shareholders, the members, they'll be able to bring derivative actions on behalf of the company. And the Companies Act extends derivative actions to include actions for breach of directors' duties. Now, in that situation, the board's unlikely to resolve to take action against itself, and it's more likely to be shareholders and creditors that will go after directors. And derivative action may also be brought even if the director has not benefited personally from the breach. Now, when we consider the impact of insolvency, so where a company is at risk of insolvency or indeed becomes insolvent, as I said before, directors' duties to act primarily in the interest of the company shift, and it's the interest of the company's creditors directors must promote. So this means that directors must manage the affairs of the company to minimize potential losses to creditors. And if the company does enter a formal insolvency process, then the conduct of directors in the period leading up to insolvency will be considered, and the company's transactions will be investigated. And I'll go through some examples of that on this slide. So if we look at misfeasance, fraudulence, and wrongful trading, now when selling or otherwise dealing with company assets, directors should be aware of the provisions of the Insolvency Act. If those running a company are found to have misapplied company property or money, carried out any business of the company with the intent to defraud creditors, or if a director knew or ought to have known that the company was insolvent or would soon commence insolvency proceedings, but nevertheless still allowed the company to trade and therefore engaged in wrongful trading, court action can be taken against them and a director can be required to contribute from his or her own assets to the assets of the company. And it's also worth flagging that fraudulent trading is also a criminal offence. Now, if we look at challengeable transactions, in the lead up to insolvency, it's not unusual to sell assets in a fire sale to raise cash. But when a director is selling company assets, it's vitally important they're not transferred for less than their true value. Don't assume that because of COVID, asset values have dropped in value. The same rules still apply. If it's found that assets were sold at an undervalue or transferred for no consideration at all, then the court may order the transaction to be set aside and steps taken against the directors to restore the company to the position it would have otherwise been in. Now, if we look at preferences, so a preference is given where a creditor or a guarantor is put in a position which, if the company becomes insolvent, it's better than the position it would have been in without the preference. Now, the golden rule here is treat all your creditors equally. Stick to your terms and conditions of business. Don't go repaying a loan from someone connected to the company, such as a director or their relative, or making sure that a creditor is paid simply to encourage an ongoing business relationship post-insolvency. This will be challenged by an administrator or a liquidator. The same applies if directors award themselves big pay rises or bonuses which can't be justified. Now, generally, excessive remuneration is remuneration which goes beyond what is reasonable in all the circumstances, considering the financial circumstances of the company at the relevant time. Directors should have reasonable grounds for believing that the company can or will be able to afford the remuneration, and if not, then the remuneration should either not be taken at all, should be deferred, or should be taken as loans. Now, we know that directors paying themselves through directors' loans and reconciling through a year-end dividend is nothing new. In fact, it's a very common way for directors to pay themselves. But doing so can be risky, even more so in the current crisis. If a company is struggling financially, then if directors are paying themselves in this way, all they're doing is building up an overdrawn loan account, and that's going to have to be repaid if the company becomes insolvent, because the company won't have generated the profits to declare a dividend to reconcile those overdrawn loan accounts. What directors can't do is backdate a dividend direct declaration to make a loan payment look like a dividend payment. That is fraud. It's also the case that if a dividend has been declared pre-COVID but not yet paid, that doesn't mean it can still be paid. It's got to be considered in the context of the current financial position of the business. So we've heard a lot in the press about the various government support measures that have been rolled out over the last 3 months, but directors need to be very careful that they're not abusing these support schemes. Now, it's been recently announced that the government have launched a consultation for draft legislation to be included in the Finance Bill 2020. And that's going to give the revenue, HMRC, the power to recover payments from the employer and the self-employed individual for reimbursement of funds received under the self-employed income support schemes and the coronavirus job retention schemes, where those recipients were not entitled to support under those schemes. Now, another example is where company debt includes some that is personally guaranteed or personally owed to directors or their associates. If a director chooses to only repay debts with a personal link, leaving unsecured creditors unpaid, this would be an act of misfeasance through the making of a preference, and an insolvency practitioner would likely challenge this, and it would lead to personal liability for repayment. Similarly, some directors applying for government-backed loans may want to use the schemes to repay loans owing to themselves. And there's a false assumption that if the company goes bust, the responsibility for repaying the loan remains with the company and it won't transfer to directors. Well, in certain circumstances, that's just not true. If directors have acted improperly, if they've breached their duties, then they can be personally liable. And as I mentioned a few moments ago, directors need to be mindful of potential misconduct and the issue of preference payments. Yes, these loans can be used to refinance existing liabilities, but directors need to exercise great caution to avoid the risk of inadvertently falling foul of the rules surrounding preference payments. And finally, for those companies looking to utilise the government's larger business interruption loan scheme for loans up to 200 million and to participate in the government's co-investment future fund, you'll have seen the curves that the Treasury have introduced on excessive remuneration and pay, companies being banned from paying dividends, cash bonuses, awarding big pay rises, all to ensure that companies and their directors don't benefit at the expense of taxpayers. So on the next slide, we're going to look at what the consequences are of a breach of duty. So where a company is facing financial difficulty, as I've said, it may be tempting for directors to have a fire sale and to take other steps to raise funds to protect their interests. But, and I can't emphasize this strongly enough, it is crucially important to remember that when a company is approaching insolvency, it's the creditor's interests that take priority. Now, the consequences, should a director breach his or her duties, will very much depend on whether the duty is fiduciary based, on trust or loyalty, or is it duty of care, skill and diligence. Now, if it is a fiduciary duty, then if the director has profited at the company's expense, he or she must account to the company for that profit, and if the company has suffered a loss, then he or she must indemnify the company in respect of that loss. But if it's a duty of care, skill and diligence that's breached, then the company itself may claim damages from the director for failing to exercise the requisite skill or care. In either case, the director's got a personal liability and is going to have to contribute to the company assets. And I put on that slide there other consequences of breach, which can include an injunction to restrain any breach or any future breach. A transaction between the company and the director may be voidable. In extreme cases, directors can be disqualified. So, as you will by now have realised, the conduct of directors and the transactions entered into in the run-up to insolvency will be scrutinised. If directors are found to have breached their duties, then they can be held personally liable, and they can be ordered to make a financial contribution to the company and to its creditors. So in conclusion, on the next slide, what are the key messages for directors? Well, I think there are two. Firstly, there's no hiding behind the existing rules, and there's certainly no hiding behind the temporary COVID-19 business support measures. Secondly, directors must act in the best interest of creditors if a company is facing insolvency. And for directors to avoid personal liability, remember, the law won't penalise directors who can demonstrate they've acted honestly and responsibly at the time the company was in financial difficulty, and the nature and scope of every obligation on directors will relate to its context. And this is especially true of any strategic or commercial decision a company's board makes in times like this. But despite the best efforts of directors, these are unprecedented times, and the fact remains that a thriving business can quickly turn into an insolvent one. So directors need to be thinking very carefully, not assume that the business support measures are a license to act inappropriately. So I'm now going to hand over to Charles. Charles is going to take you through some practical steps directors should consider to avoid breaching their duties and to avoid falling foul of the law. Thank you.
Thank you, Kieran. As Kieran has explained the core duties owed by directors, I thought it would be helpful to set out some practical tips for directors when faced with making difficult decisions in order to best position themselves to avoid liability and heightened scrutiny from the courts and insolvency practitioners. Kieran has touched on the point whereby duties owed to the company shift to acting in the best interest of the creditors in the so-called twilight period. And Marcus will be looking in more detail at the proposed reforms to wrongful trading contained in the Corporate Insolvency and Governance Bill, due for its second reading in the House of Lords on Tuesday. Directors' duties have never been more relevant and important than in these uncertain times, and it can be tempting for directors to duck for cover and bury their heads whilst not dealing with the present situation before their eyes. I thought it would be helpful to set out a few tips for directors. Firstly, directors should always act in accordance with the company's constitution. Refreshing oneself with your company's articles of association is recommended to ensure you are at all times acting within your powers. Access to up-to-date and reliable financial information is key to navigating these troubled waters. Keeping cash flow forecasts constantly updated and tested will assist in tandem with management accounts, up-to-date valuations on realizable assets on the balance sheet. Regular board and senior management meetings should be conducted with increased frequency. Thirdly, document. Key decisions need to be documented, and an audit trail will assist in the long term should the company need to be placed into an insolvency process, and books and records are to be delivered up to the insolvency practitioner. The courts will be led by the documentation, and contemporaneous accounts will be crucial in apportionment of any eventual liability and could assist in mitigating such losses demonstrating justifications for actions taken. Steps taken to act in the best interest of the company's creditors will be scrutinised. An absence of records can lead to adverse inferences being drawn and set directors up for a fall, given a witness's first-hand recollection of events can often be difficult to reconstruct with the passage of time. Fourthly, in the event that the directors believe that the company is verging on insolvency, i.e. whether balance sheet or cash flow insolvent, it is imperative that the directors of the company seek advice from a qualified insolvency practitioner to assess how the company may be rescued. New measures available to companies in the draft bill will be discussed by James. Reliance on independent advice will assist in evidencing prudent steps having been taken to consider duties owed to creditors, so long as the advice is properly considered and acted upon. An insolvency practitioner will conduct a health check on the company's finances and advise as to the best course of action to rescue the business, if possible. An insolvency practitioner should not be feared. They are office holders of the courts. They're heavily regulated in their area of expertise. Deferring to one is not an admission of defeat. Care should be taken when a director is wearing several hats in the context of a group of companies, and steps should be taken to ensure a clear delineation between entities when holding board meetings and making and recording decisions. This will assist in avoiding conflicts of interest, which inevitably are likely to occur if meetings are not properly planned and recorded. Directors should be encouraged. So let's move the slide. Can't do that. Sorry. Directors should be encouraged and take comfort from the government's measures offered since late March with the provision of the various government-backed loans, including C-bills and B-bills, amongst others, together with the deferral of tax payments and business rate relief. Whilst terms are favourable now, forecasting will remain key to ascertaining the ability of the company to settle these obligations as they roll up next year and beyond. Directors should be constantly reviewing the company's supply chain relationships. The key to monitoring here will be through effective communication. Suppliers will likely be suffering themselves and may have issues with performing their contractual duties. And touching back briefly on cash flow management, directors should consider whether their director remuneration, as Kieran's already touched on, should be pared back in the immediate term, and consider whether repayments of directors' loan accounts are truly in the best interests of the company and/or its creditors at the time. Such transactions are often areas of challenge by insolvency practitioners. The chasing of cash in from debtors will be imperative, and keeping an eye on any threatening creditor that may imperil the business. Linking into this theme, transactions outside the ordinary course of business should be avoided, particularly those which may have the effect of preferring a particular creditor. Each transaction should therefore be considered on its own merits, with consideration of the benefit of the transaction for the company. Finally, we believe there will be a number of key focus dates going forward in relation to heightened scrutiny of director conduct and the decisions taken in and around those dates. I've set out a few dates in this slide. You've got the rent quarter days, June, September, December. From the 1st of August, the dates whereby the coronavirus job retention scheme will be tapered off to include a provision for contributions by employers to employee furlough payments. Businesses in certain industries, namely hospitality and leisure, will clearly struggle to raise the cash required to provide for these top-up payments. An assessment will therefore need to be made and the cash flow position forecasted accordingly in the run-up to these dates as to whether companies can continue to sustain the employment costs going forwards until the full tapering off or conclusion of the scheme at the end of October 2020. Employment law advice should therefore be taken should redundancies need to be considered. Whilst there has been a deferral of VAT payments due between 20th of March 2020 and 30th of June 2020, these payments deferred will become due on the 31st of March 2021. And then VAT payments will still be due on the 31st of July 2020 and going forwards. I'll now conclude and just pass over to Marcus Hayward of South Square. So thank you for your time.
Thanks very much, Charles. I thought it might be helpful if I briefly summarise the claims that might be brought by liquidators and administrators against directors, and there's a summary of those on the next slide. I'm then going to talk in a little more detail about the government's proposed suspension of the wrongful trading regime, what impact this may have on claims against directors in the present context. So in essence, there are four main categories of claim that a liquidator or administrator may bring against a director. Firstly, a claim under Section 212 of the Insolvency Act. This allows a claim to be brought by a liquidator against a director where, amongst other things, the director has been guilty of misfeasance or a breach of any fiduciary or other duty in relation to the company. Secondly, under Section 213 for fraudulent trading, this section is engaged where the business of the company has been carried on with intent to defraud creditors and allows a liquidator to bring a claim against directors and others who have been knowingly a party to such fraudulent trading. Thirdly, under Section 214 and 246ZB for wrongful trading, which I'll come on to consider in a little bit more detail later on. Fourthly, claims under Section 238 and 239, which Kieran has already mentioned, for undervalue and preferences. Now, in the present context, focusing on personal liability of directors, those sections will tend to only be engaged where the director has entered into a transaction personally with the company. So for present purposes, when focusing on the potential personal liability of directors, I'll be focusing on potential liability under Section 212 for breach of duty and also for wrongful trading. So wrongful trading, moving on to the next slide, when does this arise? In very brief summary, liability for wrongful trading will arise if, in the course of a winding up or administration, it appears that at some time before the commencement of the winding up or the administration, a director of the company knew or ought to have concluded that there was no reasonable prospect that the company would avoid going into insolvent liquidation or administration, and that director did not take every step with a view to minimizing the potential loss to the company's creditors that it ought to have taken. Now, where a wrongful trading claim against a director is successful, the usual order that the court will make is to require the director to contribute the amount by which the company's assets were depleted as a result of that director's conduct. Moving on to the next slide, you will have seen that the government has announced that the wrongful trading regime will be temporarily suspended. It did that in the first instance by an announcement on the 28th of March. And when it did so, it said it was doing this in order to give company directors greater confidence to use their best endeavours to continue to trade during the pandemic emergency without the threat of personal liability should the company ultimately fall into insolvency. However, as we'll come on to see, that messaging is not entirely accurate, and the threat of personal liability for directors remains very much alive. Insofar as the liability of wrongful trading is concerned, it's important to note that the suspension that's to be introduced by the Corporate Governance and Insolvency Bill, does not in fact suspend the wrongful trading regime. Instead, what it does is it directs the court to assume, when determining the contribution a director who has wrongfully traded is to make to the company's assets, that a director is not responsible for any worsening of the financial position of the company that occurs during the relevant period, being from the 1st of March to the 30th of June, or 1 month after the coming into force of the Act, whichever is later, with a power to extend that relevant date. Now, there are three key points to note about that provision. Firstly, as I say, it does not remove liability for wrongful trading entirely. Rather, it reduces personal liability for wrongful trading during the relevant period. Now, the reason for this is apparently to ensure that directors who had pre-existing liability for wrongful trading prior to the 1st of March don't avoid that liability. Secondly, the suspension only operates during the limited period of the 1st of March to the 30th of June, or 1 month after the coming into the force of the Act, whichever is the latter, although it's possible that that date may be extended in due course. There are also a number of exclusions in relation to insurance companies, banks, electronic money institutions, investment banks, payment institutions, and others, where the suspension doesn't operate. Thirdly, as I'll now come on to discuss on the next slide, liability for directors for breach of duty will remain. So as I say, despite some of the government's messaging, it's critical for directors to be aware that the potential for liability for breach of duty, including under Section 212 of the Insolvency Act, remains unaffected by the government's reforms. This means that directors continue to have a duty to the company to have regard to the interests of its creditors when they know or should have known that the company is or is more likely than not to become insolvent. But where directors breach that duty, they will remain exposed. Insolvent for these purposes means either cash flow insolvency, so the company's inability to pay its debts, or balance sheet insolvency. So what's the scope of a director's liability for breach of duties in the present circumstances? Well, it's important for directors to remember that any breach of duty in circumstances where the company is in financial difficulty is a subjective test. Directors will not be liable if they do what they honestly think is in the best interests of the company's creditors and of the company as a whole. Now, in practice, I think what this will mean is that the court's attitude will be one that is sympathetic to directors, given the extraordinary position that they find themselves at the moment. Directors are being forced to make extremely difficult decisions as to whether, for example, to retain employees, incur further debt, including under government-backed schemes, or to cease trading. And all of those decisions are being taken in often unprecedented uncertainty as to the accuracy of forecasts for future performance. And in my view, the courts are likely to be very sympathetic to this and alive to those factors. However, the potential for personal exposure on the part of directors will remain. And ironically, I think the suspension of the wrongful trading laws and the government's message that has accompanied it, that directors can effectively continue to trade without risk, may increase the pressure on directors to continue trading companies where perhaps otherwise they should be seeking insolvency protection. So in many cases, there will therefore be an extremely difficult tightrope to walk, making it all the more important, I would suggest, to take advice. With those thoughts in mind, I was now going to move on to pass the baton on to James.
Thank you, Marcus. Afternoon, everybody. And I'm going to pick up just really that point that Marcus touched on there, talking about the tightrope. My chat's going to be largely a practical one around the various options available to directors at the moment, and really balancing whether to take up those opportunities of government support and how they sit alongside the existing directors' duties. And as I say, tightrope's a good description to pick up there, because directors, they are in a somewhat unenviable position at the moment. We are in uncharted territory. There's never been a time where there's been so many government measures thrown at them, which fundamentally go to how they structure their cash flow. Whilst this support's clearly welcome, the director must constantly be looking to the months ahead, and when making decisions as to whether to take out government support, government guidelines and the support often run counter to normal insolvency and director duty principles, and can potentially encourage directors to do what may be the wrong thing. And by that, I don't mean act dishonestly. It's more whether directors are encouraged to take out support which could potentially harm other creditors. As insolvency is likely to increase in the second half of this year, it's important, as the message has been portrayed throughout this discussion, that directors are seen to have done the right thing and recorded that documentation, that decision-making process throughout. So taking an extreme example, matters are constantly developing, but as of today's date, any board have a raft of measures available to them. So running through the main ones, some of which have already been touched on, the board have the ability to defer the VAT liability until March next year. There's been encouragement from HMRC to enter into time to pay arrangements with a specialised phone line set up with more personnel to assist with that. There's the forfeiture moratorium in place, again, encouraging parties to potentially not pay rent and to use that cash for other cash flow requirements. There's the furlough scheme, interruption loan facilities, mortgage holiday provisions, and various other options available to boards to assist them to get through this period. But just looking through all of those opportunities, the only, other than furlough, the vast majority of those either increase liabilities or simply defer them, and therefore are worsening the balance sheet later on in the year. And as furlough starts to be tapered back, that too is going to increase liabilities. So as the various stages develop with furlough, first of all, national insurance contributions will have to be paid by the employer, plus pension contributions, and then, as Charles' slide showed earlier, 10%, 20%, and then it'll gradually return back to normal. So even that, currently that's a grant which takes liabilities off the balance sheet. Shortly, furlough's going to start adding liabilities. So all of that obviously create concerns for potential insolvency in the future. So, as Marcus rightly pointed out, the courts are likely to be sympathetic to the situation. So if companies find themselves in an insolvency scenario in the months ahead, looking back on these decisions and actions where they may have deferred liabilities, increased liabilities, the starting point is likely to be that there will be some sympathy for the situation that they find themselves in. However, inevitably, creditors will still be aggrieved by not being paid, and ultimately administrators and liquidators and other office holders have a job to do in investigating the office holders of the company and how they acted over this period of time. So it's worth noting, Marcus' point when he went through the misfeasance provisions, your directors can be ordered to make a compensation repayment to the estate as compensation for his actions. And it's easy to see, and you'll see as we go on to some of the measures introduced by the Corporate Insolvency and Governance Bill, that it's easy to see a scenario where creditors, where debts may have accrued back end of 2019, early 2020, they've then been caught up in the furlough or in the lockdown scenario. They've then had measures introduced where they can't then enforce those debts. There are now new tools coming in place, particularly the restructuring moratorium, where they may not be able to further enforce the debts after the current suspension on winding up petitions. And it can quite easily be a scenario with all of the various government provisions that have been put in place where debtors can't enforce the debt for 9 months or more during this period, all the time which the board is making various decisions which are going to be questioned in the future. So there are the main defence to a misfeasance claim is under Section 1157 of the Companies Act. So provided the directors acted honestly and reasonably in circumstances, that would be a defence to a misfeasance claim. But the big question that's likely to arise in the future is what is reasonable in the current climate. So just going back to the points that I raised earlier, if you're bored now and you're looking at your options, is it reasonable to defer your VAT liability, or if you deferred your VAT liability to March next year and were to enter into an insolvency process, say the back end of this year, and a liquidator or administrator was looking at that decision, was it reasonable to defer that liability, potentially worsen the position of HMRC, Equally, you may have entered into a time to pay arrangement at that time with no real foresight of your cash flow and no real idea of what your income is going to be in the future. Equally, if there's been an encouragement to top up furlough liability, so at the moment the government only pays 80% up to £2,500 a month, the additional 20% that would also trigger PAYE and NIC liabilities, and again, is that liability able to be paid in the future? Similarly with the loan facilities that are being taken out, some parties may not pay debtors because they know they can't issue winding up petitions. The point is that the government's message is obviously to continue to trade and take advantage of all of these measures that have been put in place. But directors they shouldn't just freely run into taking up of all of these measures without clearly thinking through why they're taking out those measures. Because one of the other areas that's going to be open to potential issues is the fact that many of these measures are open to self-certification or automatically offered. We've seen in the last recession, 2008, the issues that arise out of self-certification. There's no checks and balances, and it's really on the boards to make sure that they impose their own checks and balances, whether that's internally or taking advice, so that when they're making these decisions, they've ensured that they've properly thought about the consequences for the creditors, because we are in different times to any others. A vast majority of what normally would be solvent entities are technically insolvent, mainly on a cash flow basis, and therefore they do have to give more consideration to creditors, as been touched on earlier on the discussion. So just moving on to that, and briefly touching on a couple of the measures that have been introduced from the Corporate Insolvency and Governance Bill. Whilst the bill's not currently enacted, it's likely to be receive royal assent very shortly. And a couple of the main provisions are the tools that have been added that will be new to many boards, which are the restructuring moratorium and the restructuring plan. So the restructuring moratorium, in many ways, whilst it's not meant as a replacement because it's been discussed for a number of years now, previously there was a practice to use notice of intention to appoint administrators to buy a 10 business day moratorium to either pre-pack a business or put it into administration, or potentially even consider other options. Over a period of time, that started to be abused. There was a number of notice of intentions just filed back to back to often 2, 3, 4 to establish a moratorium. But that's now, through case law, been established to be an abusive practice, and there needs to be a settled intention to put the company into administration when filing a notice of intention. So the restructuring moratorium has actually come at a good time in that regard, because presently there isn't a necessarily quick, easy and cost-effective way to put a moratorium in place without going through the courts, whereas the restructuring moratorium follows a very similar process to the NOI process. It's initially an out-of-court process, which gives a 20 business days moratorium, which can be extended by a further 20 business days without any court sanction. Beyond that, it can be increased by a year with creditor consent or court sanction. So the purpose of the moratorium is really to fend off any creditor action, which to allow the company to look at its options. In the current climate, it's obvious why that would be useful. Many businesses have been suddenly put into a situation that they weren't expecting, and they just need some time to work out what they do. At the moment, there's currently a suspension on all winding up petitions, stat demands, and other demands, unless it can be shown that the debt is not related to COVID, or the debtor's inability to pay is non-related to COVID. But once that expires on the 30th of June, the restructuring moratorium, when in place, when the corporate insolvency bill is passed, will be an important tool for many companies. The only sort of main differences to the previous or the existing moratorium that's established under the NOI is that a monitor is in place and an insolvency practitioner again, who essentially needs to oversee the implementation of the moratorium to ensure that there's a prospect of achieving an exit out of the moratorium once it expires. And then just finally touch on the restructuring plan. That, again, something that's been mooted for a while now, but just been accelerated due to the current climate. It's very similar to the scheme of arrangement and Chapter 11 process in America. It's for the larger, more complex restructurings. Often, scheme of arrangements are put in place when you are categorising different groups of creditors and maybe want to distribute cash between groups. For example, if a company wants to go into a process and they wanted to distribute some of the money available for the secured creditors down to trade creditors to keep that business going, a scheme of arrangement may well be suitable for that sort of scenario. But the disadvantage is that different groups of creditors can vote down the scheme. So the benefit of the restructuring plan is it introduces the concept of the cross-class cram-down procedure, where if a category or group of creditors vote down the scheme, similar to the CVA type of process where creditors can be bound in, that group of creditors can be bound in provided that their position is not worsened by the scheme. So those are my main points really, and I think if it's just going to give one takeaway, the main thing would be that, as I said before, many of these government schemes have been introduced to spread the pain over a much longer period of time, pretty much the vast majority of this coming year, and that in many regards increases the risk on directors because it increases the period over which they're making decisions, and it's just to bear that in mind, and again, as I touched on earlier, make sure that all decision making is properly documented and considered. So I'll pass back to Kieran because I know he's got some questions to go through.
Thanks, James. We should all be coming back on now, all head and shoulders. There we go. Super. Thank you. Well, hopefully, viewers, you found that an interesting, informative, topical, useful run through of directors' duties and what have you. A number of you have posted questions throughout, which thank you. I think we've got enough time to run through 4 or 5 of them. Think if I just take Charles, if I can ask you, I touched on liability of non-execs when I was speaking, but one of the viewers has asked, what is the position on the liability of non-executive directors and any practical tips you might have on NED?
Yeah, well, thank you, Kieran, and whoever posed the question. Well, non-executive directors are still, what it says on the tin, they're still directors, and they can therefore be liable under the Companies Act 2006, Common Law and Insolvency Act. They should review their letter of appointments and hopefully have addressed any concerns they had in relation to that on signing it, which would have included time commitment expectancies. As an NED, practical tip-wise, I would insist on receiving up-to-date, timely information, as I touched on in my talk, both financial and general. And if I was about to take an NED position, I'd want to check that there was a D&O insurance in place. So that's quite an important thing just to ensure covered in the event of any issues, any claims that may come forward.
Yeah, D&O insurance often overlooked. We come across that from time to time. Another question, James, probably this one for you. The impending retrospective suspension of winding up petitions and staff demands is having a negative impact on my trading position. My debtors aren't paying and I can't collect in. am I a personal risk by extending credit facilities to cover current non-paying debtors? So quite a lot in that question.
Yeah, so I guess that comes back to the current suspension on winding up petitions. So there is currently, well, I say currently, it's covered by the Corporate Insolvency and Governance Bill, which is shortly coming to act. But once that does come into place, there is a general ban subject to a couple of caveats on issuing winding up petitions between the 1st of March and the 30th of June. That, whilst for obvious reasons that was introduced to help the situation, try avoid insolvencies, the main detrimental impact of that is that debtor books are hard to collect in. So there's many businesses that need their debtor books as cash flow at the moment, and unfortunately that suspension has made that more difficult for them. So this question is actually something that's not uncommon. Directors looking to extend the facilities in an insolvent scenario, actually in part caused by the government measures. So I would say to that, as Marcus pointed out, if there was ever a claim brought in this sort of situation, or if this was flagged when doing a misfeasance claim or any other head, you would certainly be pointing to the current climate to say that your actions were reasonable in the current situation, which would be covered by 1157 of the Companies Act. But again, whilst it's not necessarily a sort of a cop-out answer, it's really considering all factors. If the company, if there is a proper plan to get out of its current issue by extending its facilities, then that would be a justified reason. If the company was fundamentally insolvent and the extension of the facility wasn't really going to necessarily avoid any process, then there could be a possible exposure there.
Thanks, James. I'll take the next question in the spirit of being equitable. What happens to a company where a sole director dies? Sadly, quite topical in the current crisis. Well, firstly, shareholders of the company could appoint a person who's willing to be a director. But if the deceased is also the sole shareholder, then depending upon what the articles of association of the company say, the personal representatives of the deceased would have title to the shares, and once registered as the holder of those shares, could appoint a director by passing a shareholder resolution. I suppose that more fundamentally what that does show and demonstrate is the need for companies to make sure that their constitutions are up to date. If they're not sole director, sole shareholder companies, so there are more than one shareholder in the company, to make sure they've got a shareholders agreement in place. The articles are up to date, as I say. They've got cross-option arrangements in place, ideally underpinned with life insurance policies as well. And just to make sure that ultimately those who continue in the business have clarity on who they're going to continue to be involved in business with. So yeah, sadly a topical question, slightly off topic in terms of today's presentation, but I suppose relevant nonetheless. And the final question we've had, and Marcus, if I can direct this to you. So on a different note, as we move out of lockdown, are the risks to directors increasing?
Well, yeah, I think the answer to that is undoubtedly yes. The first point we've already touched on is that the suspension of the wrongful trading regime, such as it is only to operate until the 30th of June or 1 month after the Act is passed. So after that relevant period, if there's not an extension, there'll be pressure there when the wrongful trading regime comes back. And of course, I think that the worst is yet to come for many companies. There's obviously been support to date in various forms, debt forgiveness in various forms, and unfortunately, as the year progresses, I suspect that those supports and debt forgivenesses will reduce. And finally, as Charles mentioned, there's going to be some key dates over the course of the next year, particularly when the furlough scheme is reduced and companies have to take some of the burden in relation to furloughed employees. That will be a critical date. So I think that the short and unfortunate answer to that question is yes. There will, I think, be increasing risks as the year progresses.
Okay, thanks, Marcus. It looks like we're going to be running out of time to answer any more questions, but if there are questions that we haven't been able to answer today, or topics that we discussed that you'd like to take offline, our contact details are there on the slide. Please feel free to contact any of us direct. All the questions that have been asked today, including the ones we haven't had a chance to answer, when the slide deck and a recording of today's webinar is circulated to you all next week, we'll include written answers as well. So in the meantime, all that leaves me. Sorry?
Thank you. I've got a quick question, and I've probably got a quick minute to just very quickly answer. Yeah, I've had one on that group. It's just a question about is it reasonable of a director to pay certain creditors when they've only got limited cash at bank? It really goes back to a lot of the principles that we've discussed during today. Given the raft of measures, it's really just looking at everything together, because if in that example certain key creditors were paid to just try to keep the business going, and then it did ultimately go into a process with other creditors not being paid, would questions be asked about actually should they have taken out some of the government measures? Should they have taken out some of the loans? Should they have relied on the current suspension of enforcement processes? Should they in fact relied on the we haven't actually touched on it today, but the corporate insolvency bill effectively voids termination clauses in insolvency scenarios. There may well be the reverse of much of what we said today. Is did they do enough to take out the government support to assist them? So I think to answer that question, it really goes to the specific facts of the case and looking at everything in the whole.
Thanks, James. I think that's probably a wrap up from all of us. Thank you to James, Charles, Marcus for being our speakers today. Thank you to you, the audience, for viewing. Do keep a lookout on our website and social media channels for future COVID-19 webinars coming along very soon. And finally, whatever you're doing this weekend, have a great one and stay safe. Thank you.